although he does go beyond just the felony indictment section of the Federal Firearms Act. Mainly, he does this because the government argued that the federal indictment prohibition was linked to the felon in possession ban historically, and that basically the government's argument was, well, this is the same essentially as the felon in possession ban, and Heller said in one paragraph that these are longstanding and presumptively constitutional. So therefore, the felony indictment prohibition is also constitutional. The judge rejected this argument, and part of the reason he rejected it is that he views the felon in possession prohibition as not longstanding, despite what the Supreme Court said, and having no historical analog. Do you think his analysis there is correct? Or, obviously these laws, as you mentioned, only date back to the early 20th century, and really the federal indictment provision only dates to the mid 20th century, the 1950s. So is the judge correct in his assertion that neither of these relatively substantial restrictions that are popular among most Americans are actually historically grounded?
The judge is correct. I mean, this is one of the questions that comes up in Heller and Bruin's aftermath. Heller just says in dicta that the felon in possession, that nothing in the opinion should cast doubt on the felon in possession ban, but it never explains why. And those assurances have been repeated ever since. They were repeated in McDonald. They've been repeated by various judges in Bruin, by various justices in Bruin, but never with an explanation for why. And Kevin Marshall actually wrote this wonderful law review article, Why Can't Martha Stewart Have a Gun?, where he goes through the history and notes that there was no historical analog of these felon in possession bans. And I think there are two things to note about the history. Number one, there were no bans that applied to felons as such. These are, as you indicated, mid-20th century creations. The second is that the definition of a felony is much broader today than it was at common law. So common law, early common law, there were very, very few felonies. These were like murder, rape, robbery. And then felony, the definition of a felony originally was anything that would result in the forfeiture of your lands and estates. And in the 1800s, this gets, the forfeitures die out, and a new definition comes in that's any crime punishable by more than 1 year in prison. But since then, the theoretical statutory maximum, a lot of crimes have gone up. And so you have a lot of crimes that are essentially misdemeanors, but have as a theoretical maximum penalty 2 years, 3 years, 5 years. And so the definition of a felony today is much, much broader than anything it would have been historically either. And so what you have are a lot of people who are falling within the ban, but who in substance have really done what I think traditionally would have been viewed as a misdemeanor rather than a felony.
Yeah, and in fact, I think Judge Counts goes perhaps even further than just felon in possession to essentially point out that there really wasn't much of a historical record of taking anyone's guns away.
No, the people whose guns were taken away in the early days were either people who did not, individuals who did not fall within the people, namely the political community. So these would have, at the framing, been enemy aliens, American Indians, free blacks in a lot of states where there was an open question, at least till Dred Scott, whether they were within the people. And you see in New York, in some of these cases that they're citing these gun bans as evidence. The second is that during the wars, people who were in actual rebellion were disarmed. And so that was a second category. And what the government has been doing in a lot of these cases is trying to string together these bans and say, well, there's this broad principle that anyone the government deems as dangerous can be disarmed. But that's much broader than the original bans were. But they're trying to basically adapt Bruin's historical test to what was the previous intermediate scrutiny test by just taking it at a very, very high level of abstraction and just saying the government can disarm anyone who's dangerous. But Bruin doesn't say it goes quite that generically.
Right. Yeah. I think that's going to be a big fight moving forward here, is the level of review, and this sort of how far back you need to step to find an analog. And yeah, it's going to raise a lot of serious questions about basically every gun law. It seems, especially the federal gun laws, which didn't appear until the 20th century. And so it's interesting that's why this particular case, I think, is really noteworthy, because it's one of the first to take a stab at some of these federal gun laws. And it does cast a lot of doubt on them, but then it also offers up a potential solution, right? And you sort of touched on it there, which is the Judge Counts talks about how the Second Amendment is reserved to the people, like several other rights in the Bill of Rights, the First Amendment, the Fourth Amendment, and but at the same time, those historically, there were subgroups excluded from what was considered the people, and they were in some cases felons, and others. So it's a bit more of a, I think, substantial place to root your argument than just the Native American and Catholic bans that you've seen New York cite, and on even Justice Barrett at one point. So I don't know. I'm interested in your thoughts on this particular tact that Judge Counts is taking in this case. Do you find that to be a persuasive argument for why felon in possession bans could withstand the Bruin test, if you use this sort of argument that there are certain subgroups that aren't included in the people?
I still don't think that would work. I mean, I think felons have traditionally been included in the people, and they have lost some of their political rights, but not traditionally their right to bear arms. And I think there are two problems here. One is that the analogy doesn't quite work here, and the second is, as I indicated earlier, the definition of the felony is so expanded that it covers crimes that aren't really within the scope of what a felon would have been at common law. I mean, somebody who mails a handgun commits a felony. There are all kinds of these technical regulatory offenses that
Sure.
Are punished by 2 years instead of 1 year, but they are in substance a misdemeanor. And I don't think the history would justify everyone who has committed a crime punishable by more than 1 year, no matter what the mental state is. A lot of these are strict liability or crimes that have fairly low mental states because they're regulatory offenses. Many are nonviolent. I just don't think that the history will bear out that all felons of every description are subject to the ban. Now, in the early days of the Gun Control Act, there was a restoration provision. There still is technically on the books a restoration provision that said that those whose gun rights were suspended could apply to the Secretary of the Treasury, now the Attorney General, for restoration of gun rights. But for the last 30 years, Congress has not funded that and has told ATF not to process those. And I think that's going to also raise as applied questions, that even if which has happened, there have been a few of these, and they've gotten less traction than I thought they would. But I think you will have people who will say, look, I have been convicted of a nonviolent felony. Maybe even my nonviolent felony would have been deemed a misdemeanor at common law. There's no evidence whatsoever that people who have done what I've done are violent. It's way in the past. You should restore my gun rights. And traditionally, there was an administrative process to do that. Now those people without that administrative process are probably going to re-raise it in the courts and say that the felon in possession ban is unconstitutional. And even if it's constitutional, it's unconstitutional as applied to them. And
right.
curious what will happen with that. I really have no idea.